I'm Jorge Molina, immigration attorney based in Dallas, Fort Worth, and I'm with Lorena Castillo, also an immigration attorney based in Dallas, Fort Worth. And today we have a special live event in which we're going to be discussing the Family Parole in Place program, addressing your questions, and just highlighting a few important things about this program. Okay, if you would like to submit a question or if you weren't able to watch this live, you can always send us an email at info@jmolina.law. But without further ado, here's Lorena Castillo for an overview of the Family Parole in Place program.
Yes, so as of August 19th, 2024, the new Family Parole in Place has taken an effect. So to be eligible for this parole, you must be the spouse of a U.S. citizen and meet certain requirements. You must be in the U.S. without legal entry and have continuously lived in the country since at least June 17th, 2014. You must also have a valid marriage to a U.S. citizen on or before June 17th, 2024, and have no serious criminal history, and pose no threat to the public safety, national security, or border security. Also, you need to submit biometrics and undergo background checks and pass the national security and public safety screenings. This is also for stepchildren of U.S. citizens. So for non-citizen stepchildren of U.S. citizens, the criteria is slightly different. They must be under 21 and unmarried on June 17th, 2024, and be in the U.S. without legal entry. They must also have lived continuously in the U.S. since at least June 17th, 2024. Their non-U.S. citizen parent must have been married to a U.S. citizen since on or before June 17th, 2024, and before the stepchild turned 18. Like spouses, stepchildren must have no serious criminal history, pose no threat to public safety, national security, or border security, and must also submit biometrics and undergo background checks and pass required vetting.
Okay, well, great. Thank you for that presentation, Lorena. Now, when you say no serious criminal history, what does that mean?
So you can't have any felonies. You can't have any crime that UCIS triggers to be crime against moral turpitude. These are crimes such as murder, torture, sexual abuse, offenses with firearms, aggravated assault, things like that.
Okay, so let's say someone doesn't have any of those things, right? So you haven't committed murder, kidnapping, anything, and any aggravated felony. But let's say we have a DWI. Can you still apply?
So for the DWI, you're still eligible to apply for the parole in place unless it's a felony. Some DWIs can turn into felonies after the second or third DWI. So as long as it's still classified as misdemeanor, it doesn't disqualify you from applying for parole in place. But do keep in mind that this is also officer discretion. So the officer has the discretion to whether approve or deny your application.
Okay, so if it's discretionary, what and if we have a criminal history, right? So what should we be providing to USCIS if we do have a criminal record?
First, you need to provide your whole criminal history with the final dispositions of what the charge was. Also, you need to submit documents to prove that you're a good person, have good moral character, and that you're rehabilitated. So if you're in church, a letter from your pastor, from the church, members from the community that can show that you volunteer or do anything that shows that you're a good person, letters from family members and friends that can show that you are rehabilitated, you're not that same person, and that you deserve to be approved. You deserve to have this parole in place approved.
Okay, very good. You said something interesting. You mentioned a final disposition. What happens if we have an open or pending case? We're still completing probation. What happens in those cases?
Unfortunately, those people who still have a pending criminal case or have probation aren't eligible for this. So for the parole in place, what UCIS is asking for is for the case to be completed, to be closed, and to not be pending.
Very good. Okay, so why would people want to apply for this? I mean, what's the point of all of this program?
That's a great question. So it's an amazing program because it allows people to gain legal entry into the United States, which means they don't have to go to their home country to do the interview. They can adjust here in the United States.
Okay, and then if someone doesn't do this program, what is the other alternative? Let's say they're married to a U.S. citizen. It's a legitimate marriage, but they don't have a lawful entry. What would be the other way that they could fix their papers?
So it would be the normal way that we have now would be filing an I-130 on behalf of that spouse. Then we would have to do a waiver, el perdón. It takes about 30 to 40 months for that to even be approved before we can get the interview at the consulate. So it takes more time, it costs more money, and you have the risk of having the person leave the country and do their interview in their home country.
Okay, great. All right. So how about marriage, right? So we are in Texas. A lot of states in the United States follow the common law marriage principle. Are common law marriages accepted for this program? What can we do if we're in a situation like that?
Yes, so in Texas, like you mentioned, common law marriage is lawful, but UCIS has a policy that we require to show a marriage certificate. So if you are common law married and you don't have the marriage certificate, and then you register common law marriage, sorry, the certificate will have the date after June 17th. So it'll probably have a date of August. So what we need to do is we need to argue that you were married before the date. Now, we don't know how UCIS will decide this, how they're going to decide the factors of whether this common law marriage is lawful and their requirements with the marriage certificate. But there is a way for us to argue, but again, it's up to the officer's discretion. We don't know what they're thinking.
Okay. Yes, and that's a very good point, right? So it's up to the officer's discretion. This means that even if you are common law marriage, even if it's recognized by your state, if we're not able to show to the officer to their satisfaction that you're actually married, we can't really do much because under this program, because it's wholly discretionary, we do not have the right to appeal. We do not have the right to force them to make a decision. So, it's in our best interest to present the strongest case possible under the facts. So if you're in a common law marriage and you think you qualify for this, consult an experienced immigration attorney that can help you present the best case to show that you are actually lawfully married. Okay. And then here's one. Common law marriage would be one of those things that really is very fact specific. So, for example, if you've been with your partner for about 15 years, you have children, you very clearly bought property together, you hold to the public and to your church and everyone, and then you can provide testimony to this fact. I think that would be a very strong case to make, right? But if it's, you're just living together with your boyfriend and, you're not 100% and you don't have a lot more evidence, well, it might not be as strong. But very good points, Lorena. Is there any other points that you'd like to make before we open it up for questions?
Yes, so this application is completely online. So you must have a UCIS account in order for us to submit this application, and I need to have an email that you're able to access. And there is a filing fee for this application. UCIS is currently charging $580 for this application.
Okay, very good. And how can you pay for that application?
So you will be paying online through your UCIS account with either a credit card information or your bank account.
Okay, beautiful. Very good. And then on that note, here are a few observations that, based on the work that we have completed this week, right? So we are already working in a lot of these cases, and we're noticing a few things. Okay, so the hard thing about this process is not the application itself. The application is fairly simple. It's mostly biographical information and some background information about individuals. The challenge is the evidence establishing that you're eligible for this, right? So they want 10 years of showing presence in the United States. So a lot of people don't have that presence, right? So either you were working in a rural area and, didn't really open a bank account or anything like that, or you just lost your paperwork, you moved and lost everything, or you never kept them, right? So that's very important, right? So what you want to do to CIS is make it as easy as possible. So you want to document every year of presence in the United States. So if you have tax returns, fantastic. Bank statements, very helpful. Photographs showing, a landmark or something like that would be helpful as well. But you're only limited by your imagination in what you can use to prove your case. So in some cases, in another context, we've proven presence in the U.S. through Facebook, right? Just using the timeline of Facebook. So, if you're in that situation where, well, I can't really document 2015, but I have something for 2014, perhaps some affidavits would help you. Okay, but that's the trend. That's what we're seeing. That's the most time consuming part. But on a positive note, we've also noticed that USCIS is actually already approving a lot of these cases, um, especially for individuals who submitted provisional waivers and already submitted their fingerprints. We are seeing some approvals quickly. And then finally, before I open it up for questions, an observation about the political climate. I think it's in everyone's best interest, and I think that the government recognizes that acting promptly in this program is important for a few things, right? So, one, as we have seen in other programs, a government program can be stopped by a lawsuit. So we don't know if there's a lawsuit coming around the corner. I know it takes some time to prepare lawsuits and demands and stuff like that. So the quicker you apply for this, the less likely it is that your application will be stopped by a lawsuit. Additionally, I think that CIS recognizes that and they're acting promptly on these. That's why we're saying that they're approving cases fast. And then if there's a change in administration, let's say a Republican administration comes in, I think they have already said that they will stop this program. So again, time is of the essence to get this benefit. And this is a great benefit. It really is. Just avoiding the stress of having to go abroad for a consular interview. By the way, consular posts are renowned for being really tough on people. So that's a great benefit. That's one. Two, doing everything from your home, right? With your spouse, with your children, your responsibilities. That's another benefit of this program. So to me, if you're in that situation, if you already filed a waiver or you're about to, or that that's the only way that you're going to be able to fix your papers, this is the way to do it. Okay. But that's it, guys. Let's see if you have any questions. A beautiful question. So Lucas asked, my husband became a citizen in February. Am I eligible? Well, based on your husband's citizenship, yes, you are eligible. However, you still need to, comply with the other requirements. 10 years presence, right? So presence since June 17th, 2014, and a lawful marriage before June 2024. I'm assuming you're already married or you were married before then. And then no lawful admissions. That's an important point. If you have a lawful admissions, you're not eligible for this program. Okay, because that's what this program does, right? It gives you that ability to have technically it's not really a lawful admissions, it's parole, but it's very similar to it. It fixes the same problem. But very good question. It doesn't matter when your citizen spouse became a citizen, as long as it was before June 17, 2024. Great question. Right. Okay, so while we wait for some other questions, here's another important thing, right? So importantly, when they made this announcement, they made an exception for widows or widowers. Okay. So if your U.S. citizen spouse passed away before you can complete the process, let's say you're waiting for a provisional waiver, or you just submitted the I-130, you're still eligible for this program. Okay, so that is a great benefit. Um, though practically speaking, you can also apply for an I-360 if your spouse died before it was adjudicated, but it really does depend on your circumstances. But only because your spouse died before you could get the I-130 or something like that doesn't mean that you're disqualified. Okay, so there's that exception for widows. Okay, so Sandra asked, if you have an asylum case and you are not up to 10 years, do you qualify? So let me understand this. So you have an asylum case, but you don't have 10 years yet. So, the 10 years of presence is a requirement. If you do not have the 10 years, you don't qualify, even if you're short by 1 day, right? And then I've seen situations like this, and it breaks my heart. Been here almost 10 years, but they arrived, 10 days later. And there's an entry, there's a record showing that they entered in that, 10 days later. There's nothing we can do. You can't lie. You're submitting this under penalty of perjury. They're also running background checks on you. So unfortunately, you won't qualify. But in some other cases, right? So you maybe don't remember if it was May or June of 2014. Maybe you're really young. We can investigate that. But if you already know that you don't qualify because you don't have 10 years quite yet, that's it. You don't qualify, unfortunately. And you're going to have to follow the traditional path. But I think the question leads to the following. Also, if you have a pending case, listen, you're eligible to apply for this benefit if you have a pending case. As a matter of fact, even if you have an immigration court case, you're still eligible for this as long as you meet the requirements. You can still apply for this. By the way, we have quite a few cases in court that will benefit from this, right? That we're not going to have to follow the court process, because now we're going to have lawful admissions, and we have another way of fixing our papers in the United States. Okay, so even if you have another case pending, you can still apply for this matter. Here's a few other questions. Okay, so can I apply for parole with an aggravated felony not under this program? Okay, it's very clear. If you have an aggravated felony, you're disqualified. And then, as a matter of fact, if you have any felonies, you're disqualified. Okay, so can I apply for the program if I entered with Venezuelan humanitarian parole? You cannot, because it requires 10 years presence in the United States. The humanitarian parole program for Venezuelans started last year. So by definition, you weren't here for 10 years. So you're disqualified. Okay, so what happens if I already sent a provisional waiver? Can I apply? So yes, you can apply. As a matter of fact, most of the people, I would say, or a big significant chunk of the people that are applying for the program already submitted provisional waivers. As a matter of fact, the application asks you if you submitted a provisional waiver. And what does it mean? It means that, fortunately, if you already filed a provisional waiver, you already took fingerprints. It also means that if you're filing a provisional waiver, you do not have a disqualifying criminal conviction, right? Because it's very limited to why you could request a provisional waiver. So if you have a CIMT, you're out. You can't request the provisional waiver. Or if you had a DWI, let's say they already told you, it could be risky. But anyway, if you have the provisional waiver, yes, you're still eligible. Likely, if you submitted biometrics, it would be approved promptly. And if it's not approved or there's a change, right? Let's say you apply for this and you have submitted the provisional waiver. What happens if it's denied or they end the program? You're left in the same spot. That's it. You're left how you are. No, you're no worse, no better. But if it's approved, you're much better because you're not gonna have to wait for that provisional waiver. Lorena, would you like to add anything to this, or just any point of these questions?
Yeah, I want to go back to the removal order if you're in immigration court. So those who meet the other requirements are married to US citizens since June 17, 2024, have been here for 10 years, and are currently in removal proceedings. So you still have an active case in court. You are still eligible if you don't have a final order removal. But let's say you entered as a child with your family and you're placed in immigration proceedings and you got the order removal. You are still eligible if you meet certain requirements. So what we would have to show is the reason for why you didn't show up to court. Was it because you had lack of notice, didn't send you the notice, or were you just too young and you weren't physically able to go to court? So just because you have a deportation order or you're currently in court doesn't mean you're not qualified. You are eligible for it if you meet the other requirements. So please seek the please seek the advice of an experienced immigration attorney that can help you through this process and help you see if you meet all the requirements.
Yes, and that's a very good point. Here's another thing. We know that under case law, if you're a minor and they didn't take you to court, that is a reason to reopen your case. Also, on, until 2018, or frankly, in a lot of jurisdictions until 2021, DHS was not telling you when you had to show up to court. And if you didn't receive a hearing notice from the immigration court, you wouldn't know when you had to show up. So how would they expect you to show up? So in those cases, what we're seeing is that while we're filing these requests, we would also file a motion to reopen the proceedings at the same time. And then depending on the case, maybe even a stay of removal while the court decides on on that motion. Okay, but yeah, very good point. You're still eligible, and then do talk to an experienced immigration attorney. Doesn't have to be us, can be anyone that is trustworthy and can help you understand your case better. Okay, so here's a few practical notes on this, right? So as Lorena pointed out, this service is completely online. So it means that all the notices are going to be coming to your USCIS account. So that means you need to ensure you have access to your account. Now, at the beginning, I told you that, one of the things we're noticing is the harder part is presenting the evidence accurately in a way that's easy to understand and process for CIS officers. What happens if this is not the case? Likely, what's going to happen is that USCIS is going to send you a request for further evidence, an RFE, and then they're just going to pretty much ask you for everything, right? So we see that you have a criminal history, show that you have been rehabilitated, or why, as a matter of discretion, we should approve your case, right? So to prevent those things, because that really does delay the case significantly, right? So to prevent that, our practice has been just to submit everything when it's complete and we address all the issues to avoid those delays. Okay, because we know if you have a criminal history and you're not providing the full record, they're going to want to see them, or they're just going to deny the case. So to prevent that, submit a complete packet from the beginning. Don't wait for CIS to ask for more evidence. All right, folks, Item C, thank you for the information. Okay, you're welcome, Lucas. It's been a pleasure. Okay, we are actually very excited to help so many families on this program. I think this is a great benefit, and it goes to the heart of American families. and it's a pleasure to help all our clients on those matters. Okay. We're going to have more information as we work on with this program. Thank you for watching. My name is Jorge Molina, and
Lorena Castillo.
yeah, thank you.